Excuse me, sir. Is the Earth round or flat?
Flat.
Why do you say that?
Because of the firmament.
What's the firmament?
Do you even read the Bible, bro?
What up, what up? You are now listening to Once Upon a 785, the dopest podcast in the Midwest. I'm your host, Georgie350. Let's get into it, bitch. What up, and welcome to another episode of Once Upon a 785. Today's date is November 12th, 2024. As always, I'm your host, Georgie350, and welcome to episode number 20, the United States Corporation. But, as always, before we start, let's do some quick announcements. You already know, I have 3 places you can go and get some dope clothing. First is habits365.com and use promo code Georgie350 to get 15% off your order. Next, you can go to reaperapparelco.com and use promo code Georgie350 and get 10% off your order. And last but not least, you can go to cocoburry.com for your premium sweatsuits, all different colors, and use promo code, you guessed it, Georgie350 to get 30% off your order. And for all my true earthers out there who know what the shape of the earth is, and if you haven't checked out the Flat Earth Sun and Moon clock in the App Store, you should definitely check it out because David Weiss is doing great things for the Flat Earth community. But you should use my referral link so they know that I sent you. If you don't use the link and download the app, just use referral code Georgie. And moving on, if you would like to watch this episode, instead of just hearing it, for $5 a month, you can go to patreon.com/onceupon785. You'll get the episodes before everyone else. I'll do shout outs. Plus, I'm going to start doing some Patreon exclusive episodes. Also, questions, comments, or if you would like to come on the show, you can email me at onceupon785@proton.me. That's as in Mary, E as in everybody. Lastly, if you enjoy the show and you want to do me a favor, you can go ahead and leave a rating or a review, or just share the episode with someone who you think might find it interesting. Either way, I appreciate it greatly. And now, let's get into today's episode. All right. So, the United States Corporation. And I'm not going to lie, this totally might be a 2 or 3 part little series, I guess. I called it the United States Corporation because if you're like me, you had no idea that there's actually the United States and the United States, the corporation. 2 different entities, and, you know, everything from our birth certificates to our driver's license, it's all a scam. And I found this here PDF file, and it's phenomenal. And I don't think I'm going to be able to read 107 pages. But I was going to just summarize it, but this PDF is literally gold. I mean, it's like one of the best things I found, and I found some videos and stuff, so it's going to be good. I mean, it blew my mind when I found out, so if you haven't heard of it, I hope it'll blow your mind. It's called Everything you know about the United States and its laws is wrong. The, in quotes, United States is not the, quote, United States of America by John Henry Hill, MD. He wrote it April 26, 2013. And he started with a quote from Thomas Paine. It says, quote, "A long habit of not thinking a thing wrong gives it superficial appearance of being right." So he's got a preface that says, "Almost everything you think you know about the government of the United States of America and its laws is wrong. Not just a few things, but rather almost everything." When the Union of the various states was formed, the American people were not illiterate peasants. They understood very well the meanings of the words and terms used in the Constitution, and they knew the difference between common law, equity or contract law, and admiralty law, which are the only types of law allowed by the Constitution. Indeed, the founders and the people in general understood in such a great detail that the concepts on which the Union was to be founded that they put us to shame by our ignorance. Now, he starts off with the importance of definitions. In order to communicate more effectively, many professions have developed specific vocabularies containing very precise definitions. The vocabulary in everyday English as used by the public changes greatly over relatively short periods of time. Conversely, in order to maintain precise meanings of words, the vocabulary of certain professions is very stable. Words tend to retain their meanings over long periods of time. For example, in medicine, the phrase heart attack is often used by the public. However, for a medical doctor, the term heart attack means little. Instead, he would refer to a very specific cardiac event such as myocardial infarction, death of a heart tissue due to insufficient blood and oxygen, or an arrhythmia, an irregular heartbeat caused by abnormal electrical conduction, or ventricular fibrillation. You get the point. Similarly, very precise and stable vocabulary has developed for law and the legal profession, what some have called legalese. Indeed, in law, many definitions have remained fairly static over centuries, and when a new term is used or a new meaning is given to an existing term or word, that term is usually explicitly defined within that new statute. The problems arise when the definitions of specialized terms used by a profession department from the definitions used by the general public so that the terms become misleading or totally inaccurate. For example, the term client in ordinary English refers to a customer. However, in law, a client is a man who is mentally incompetent to act on his own behalf in court. Pretty crazy. It gets crazier. In ordinary English, a person refers to a man, woman, or child. In law, a person is defined as a legal fiction and a corporation. You can look all this up in Black's Law Dictionary. This is what all the lawyers use. Black's Law Dictionary. You can find it on archive.com. Just type in Black's Law. Likewise, in law, a human being is defined as a monster. I'm going to say that again. In law, a human being is defined as a monster. A citizen is defined as an officer or employee. The word must means may. The word including is inclusive, meaning it means only the items following the word include. And even the term United States has at least 3 different legal definitions within the U.S. Code and Supreme Court decisions. All right. So I'm going to read this, and then it's going to keep getting crazy. If you've never heard this before, it'll blow your mind. Okay. The word shall. The following court decisions leave no doubt about the legal meaning of shall. That's S-H-A-L-L. Shall means may. Thus, when a statute states that you shall do something, it is in truth stating that you may or may not do something. You are not obligated to do it. The choice is yours. As against the government, the word shall, when used in statutes, is to be construed as may, unless a contrary intention is manifest. That's Cairo and Fulton, RR.co, B. Heck 95 U.S. 170, the U.S. Supreme Court. Shall in a statute may be construed to mean may in order to avoid constitutional doubt. That's George Williams College, the Village of Williams Bay, 7 NW.2D 891, the Supreme Court of Wisconsin. If necessary to avoid unconstitutionality of a statute, shall will be deemed equivalent to may. Gow v. Consolidated Copper Mines Corp. 165 Atlantic 136. Now, we're going to get into automobile and motor vehicle. Now, you'll see on TikTok probably all these people making fun of people that are saying they're sovereign citizens. You don't want to say you're a sovereign citizen. I'm pretty sure you're supposed to say you're a national. You know, sovereign citizen is something that they made up to make people look crazy for understanding the law. And they don't like it when you understand their lingo. So, automobile and motor vehicle. There is a clear distinction between an automobile and a motor vehicle. The word automobile connotes a pleasure vehicle designed for the transportation of persons on highways. American Mutual Liability Insurance Co. vs. Chapit 60 A.2D118, 120 95 NH200. A motor vehicle or automobile for hire is a motor vehicle other than an automobile stage used for the transportation of persons for which remuneration is received. That's International Motor Transit Co. vs. Seattle 251P.120. The term motor vehicle is different and broader than the word automobile. That's from City of Dayton versus DeBrosi, 23NE.2D647, 65062, Ohio, app.232. The distinction is made very clear in Title 18 U.S.C. 31. Motor vehicle means every description or other contrivance propelled or drawn by mechanical power and used for commercial purposes on the highways in the transportation of passengers or passengers and property. Driver is defined as a person operating a vehicle in commerce, that is, being paid for doing so. Transportation is defined as the movement of goods or people in a vehicle engaged in commerce. A carrier is defined as a business engaged in the movement of goods or people in commerce, that is, being paid to do so, also. Use for commercial purposes means the carriage of persons or property for any fare, fee, rate, charge, or other considerations, or directly or indirectly in connection with any business or undertaking intended for profit. Clearly, an automobile is private property in use for private purposes, when a motor vehicle is a machine which may be used upon the highways for trade, commerce, or for hire. State and federal governments have the authority to regulate commerce within their respective jurisdictions because any business corporation is a creature of the state. Since a corporation is a legal fiction created by the state, that corporation's use of public roads for financial gain may be regulated by the state via legislated statutes. The legal concept of financial gain, often called simply gain, is important to understand as it means profits derived from investments and or from the labor of other people. It does not mean money earned by a man's own labor. However, under the common law, still the primary law in America, superseding all statutes and numerous Supreme Court rulings, a man traveling upon a public road in a private automobile who is not being paid for doing so is exercising his common law right to travel and is not subject to any legislated acts or statutes or any regulations derived therefrom, and therefore is not subject to speed limits, car registration, or any other regulations derived from legislated statutes. Boom. In common law, legislated statutes or acts are not law. These statutes only gain the force of law upon the consent of each individual man or woman. Under the common law, a man or woman commits a crime only if they injure another man or woman or that man's property. Technically, in law, a man's rights and his body are considered his own property. Okay, so if he injures another man or that man's property or causes a disturbance of the peace, under the common law, a man has the unlimited right to enter into a contract or conversely to not enter into a contract. No contract forced upon a man is considered valid, but instead is considered null and void, ab initio, from its beginning. The key factor is that a man may waive some of his rights under the common law by entering into a contract with another party for consideration, the mutual exchange of things of approximately equal value. A man's rights under the common law are waived to the extent specified in that particular contract, and the ancient maxim under commercial law, then applies. The contract makes the law. In short, this maxim means that the terms within the contract upon which two parties voluntarily agreed become the law on which disputes regarding that contract will be settled. Applying for and receiving state-issued driver's license is such a contract, in which you voluntarily admit you are a driver operating a motor vehicle engaged in commerce. Therefore, by obtaining a state-issued driver's license, you voluntarily confirm that you are a driver engaged in commerce and thereby submit yourself to the jurisdiction of the state's statutes and regulations. Of course, even though you may possess a driver's license, perhaps you are a taxi driver. You may not have been getting paid for transporting people when the police stopped you for speeding. However, because you have a driver's license, the presumption exists that you are engaged in commerce and therefore subject to statutes and their jurisdiction. And since you probably do not rebut this presumption to the court in a written sworn affidavit prior to going to court, this unrebuted presumption is accepted as a fact in law by the court. Two maxims of law apply here. A presumption not rebuted becomes a fact in law, and he who does not object agrees. But let us not get too far ahead. So, before we move on to the next part, I just got some videos that I want to play that they break down how you can. One guy, he hasn't had a driver's license for like 30 years, and if he gets pulled over, he can sue the police. There's another video about a guy, he will literally tell you how it's legal to not have a license and drive. And I'm not sure if I have another one, but we'll watch these two, and then if there's another one, I'll stop in and let you know.
Hi there, my name is Brandon, and I'm making another video. This time I'm trying to make it completely clean, that way I can buy ads. This is my brand, and you can look me up on my clean version of my URL, which is don'tbeaslave.com. And today, in less than 10 minutes, I'm going to teach you how you can operate any vehicle that you want without a driver's license, without smog, without license plates, without registration, completely legally, and so where police can't pull you over at all, completely legal. So first and foremost, we're going to be looking at the United States Code, which is divided by title. As you can see, there's all these different titles, right? The first thing we're going to be looking at is Title 18, which is Crimes and Criminal Procedure. We're going to go to 18 USC Section 31. This first number is the title. This is the body of law. This is the section symbol, and this is the section number, definitions. And you can type this into Google. You don't even need the S symbol, and you can just do USC. This will pop right up, including anything else I might show you on here. Very easy to find. Now, you go where? To the Bureau of Motor Vehicles or Department of Motor Vehicles to get your license plates and your driver's license and everything else. Well, everyone assumes what a motor vehicle is. Here's your definition right here. 18 USC 31 subsection A6. The term motor vehicle means every description of carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes. It's blue and underlined like that because that means you can click on it. It's got a special definition, which we will cover. On the highways in the transportation of passengers and property or cargo. Whoa. Now let's go down and check out what that means. Used for commercial purposes, right? The term used for commercial purposes means the carriage of persons or property for any fare, fee, rate, charge, or other consideration, or directly or indirectly in connection with any business or other undertaking intended for profit. So a motor vehicle is a vehicle that's transporting people or goods in exchange for some sort of monetary, specifically and explicitly for transporting that person or thing from point A to point B, such as if I paid you $10 to transport a box from my house to my friend's house, or if I was a chauffeur, such as a bus driver, or if I was a taxi driver in New York, or an Uber driver, or a Uber Eats delivery guy. These are all motor vehicles. So you driving around or moving around in your own car for non-commercial purposes would not technically classify as a motor vehicle. You can even see here in California, they separate this out a lot. This is from, you just type in California Vehicle Code definitions, this will pop up. A commercial vehicle is a vehicle which is used or maintained for the transportation of persons for hire, compensation, or profit, or designed, used, and maintained primarily for the transportation of property. Whereas an automobile, you don't go to the Department of Motor Vehicles for automobiles, by the way. An automobile is a passenger vehicle that does not transport persons for hire. This includes, now it says includes, it doesn't mean is exclusive as only. It just says includes, meaning it could be one of these things or maybe other things too. Station wagons, sedans, vans, and sport utility vehicles. So wait a second there, Brandon. You mean to tell me that I drive around in a way where the state believes that I'm driving in a commercial activity and it's some kind of a job, or I'm transporting people for property for money? Yep. Now this gets even more wild because we've got the next thing here, which is 49 Code of Federal Regulations, section 390.5T. You've heard a lot of these sovereign citizen type people driving around saying, I'm not driving, I'm traveling. But they never say where that comes from. Well, let's see. What is the definition of driving or driver? Driver means any person who operates any commercial motor vehicle. So when you get a driver's license, or when you give the police officer your driver's license, in that moment you're saying, Hi officer, I am operating a commercial for-hire motor vehicle. You have full jurisdiction over me. So you ask me, well, if a driver's license is a commercial activity, then what does that mean? And I say to you, well, if it's a commercial activity, then that's how the police and the state get jurisdiction. And we're going to go over jurisdiction a little later in this video. Commerce is within their jurisdiction. Non-commerce is not. So you ask me, well, how do I operate these vehicles and do these various things outside of commerce? The answer is a passport card. On the DSL, the application for a U.S. passport, you can get a U.S. passport book, U.S. passport card, or both. A lot of people don't realize, too, is you can get a regular book or a large book. Get that card, carry that card. Now, when it comes to jurisdiction, there's two types of jurisdiction. Personal jurisdiction is the requirement that a given court have power over the defendant based on minimum contacts with the forum, right? Basically just means jurisdiction over you as the human being. Subject matter jurisdiction is the power to hear a certain kind of claim that is brought to that court and can also include the vehicle in question or the activities in question. One of the easiest ways to break personal jurisdiction, as well as subject matter jurisdiction to some degree, is this passport card. But if you go above the DMV, they have this thing called the Federal Motor Carrier, right? Now, there's two types of motor carrier. There's a private motor carrier and a for-hire motor carrier. A private motor carrier transports its own cargo, usually as a part of a business that produces, uses, sells, or buys that cargo that is being hauled. A private motor carrier transports its own goods and is not required to have a U.S. DOT number, but does not need operating authority. Heading back over to 49 CFR 390.5T, for-hire motor carrier means a person engaged in the transportation of goods or passengers for compensation. So this is very, very interesting. Going online and getting a private motor carrier DOT number is completely free, and it's attached to some sort of business or trust. Ideally, you would create a trust, and then you would attach it to the trust, which is more complicated than this short video can go. This is kind of like just to give you ideas. You only need one of these numbers for every single car, motorcycle, everything that you have that is not operating in commerce. And you actually can create your own license plates with this private motor carrier DOT number, and you can operate these vehicles outside of a commercial activity, and you never have to go to the DMV ever again, and it's all free. There's no smog, no registration, nothing. But we're going to cover what is registration exactly. As far as I can tell, registration is the Motor Vehicle Theft Prevention Program from 34 U.S.C. 12611, and it's going to piss you off, probably. Motor Vehicle Theft Prevention Program. The owner of a motor vehicle, which is a commercial vehicle, may voluntarily sign a consent form where you basically say that the vehicle is not operated under normal specified conditions. You agree to display program decals on devices, which is probably the registration sticker, and it permits law enforcement officers in any state to stop the motor vehicle and take reasonable steps to determine whether the vehicle is being operated by or with the permission of the owner. They don't need reasonable articulable suspicion or anything when you have current registration, as far as I can tell. You're waiving all your Fifth Amendment rights and everything because you're involved in a commercial activity. You are not private. Another important thing when it comes to breaking subject matter jurisdiction is the manufacturer's certificate of origin, which this is hilarious. It comes straight from the American Association of Motor Vehicles, which is commercial. Manufacturer certificate of origin, MCO, refers to the original ownership document for a vehicle. So this is from California, new vehicle with MSO registration requirements. When a new vehicle has never been registered or titled in any state or country, If you do an application for title or registration, you send the superior title, which is the manufacturer certificate of origin, properly endorsed, which means released, to the state. So you're exchanging the superior title, which is the MSO, MCO, for a stupid certificate of title. Now they call it, once a vehicle has been issued a state or jurisdiction title, the MCO, MSO is no longer available. They destroy it because now they own the vehicle. You just gave your vehicle to the state. The police is policing what is owned by the state. They're not policing anything that you own. So combining the power of the passport with the MCO or MSO, and then also having the private motor carrier DOT number, you're completely outside of commerce. No smog, no driver's license is needed. Police can't do anything to you. Now, it doesn't stop the sheriff's office from doing something with you if you're causing accidents or harming people. That wouldn't be statutory. That would actually be found under common law. So you can still get in trouble for driving like a crazy man. It's just that you're not donating your car and everything else to the state. I have a lot of free information on my website. It's completely free if you want to learn more. I don't even want your money. Don't even try to give it to me.
What up? I hope you enjoyed that video. I would like to say I got that from One Stupid Buck on TikTok. He has a whole bunch of other videos. Highly recommend him. And there is 2 more videos. One from the great Carl Miller, and then another one of this guy getting interviewed that hasn't had a driver's license for like 30 years. So we'll be back after these 2 videos. Enjoy.
What is called positive change. And every time they see you and that goofy hat you wear, they go, for God's sake, don't give that guy no ticket. I have actually been pulled over, listening to the program, didn't have no plates on my car. Policeman called, he says, you got positive ID on the guy? And a friend of mine was taping it off his police radio. He said, yeah, it's him. He said, well, for God's sake, don't give that guy no ticket. And the guy says, Sarge, he ain't got no plates on his car. I said, I don't give a damn what he ain't got on his car. Don't give that guy no ticket. He said, but Sarge, he told me he's just been waiting to fight it and beat it all the way to the Supreme Court, and I wrote that on the ticket. He says, you give that guy a ticket? I said, I just told you not to give that guy a ticket. What are you, deaf? You got some problem with your hearing? He said, I told you not to give that guy a ticket. Now, why did you give that guy a ticket? He said, Sarge, he ain't got no plates on the car. I said, I told you I don't care what he ain't got on the car. This is all recorded on a radio broadcast. So everybody was laughing. The police were laughing. Everybody was laughing. His buddies were laughing. They were ribbing him over the radio. The sergeant told him, all right, knock it off. Clear the net. This is serious. He said, fine. He said, you give him a ticket? He says, fine. He says, tomorrow morning at 9 o'clock, I want you to be in here when the city attorney comes in here. And he says, you're going to personally deliver the ticket to him, and he ain't going to be real happy with you. Because he hates that guy. Every time he goes to court, that guy blows his doors off. He looks like a fool. You give the guy a ticket. Now he's got to go to court. So sure enough, we go to court. Come up before the court. Judge starts operating like a prosecutor. He starts asking me all kind of discovery question. I call it as soon as they call the case. Now this is something important. You got to understand. You're going to be your own attorney, and you got to know all of the programming. When you hear him call your case, you get off your tail feather and you run right up there as quick and expediently as possible without knocking anybody down, and you say, "Ready, Your Honor." You state your appearance. I'm so-and-so, hearing before this honorable court. I am standing as my own counsel. In my state, it's under Article 1, Section 13. I've appointed myself my own attorney, and I'm ready to proceed with my administrative and procedural matters. And at this time, Your Honor, may it please the court, I motion for dismissal with prejudice, failure to state a cause of action for which relief can be granted. Bingo! Now, I apologize if I'm talking too fast. I'm going to try and slow down a little bit, but when you're in court as much as I am, you just learn. You either talk fast or you lose. So I apologize if I'm going a little too fast. I'm going to slow down. I'm trying to make it easier for you folks, okay? Dips off right away. Well, you got a ticket on such and such. I said, "Whoa, Your Honor." I said, "Are you the judge, the disinterested third party that's trying this case? The trier of fact?" He said, "Yes." I said, "Okay." I said, "Is this the prosecutor over here to my right?" He said, "Yeah, that's him." I said, "Okay." I said, "Are you going to prosecute this case, Your Honor?" He said, No, I'm the judge." I said, "And why are you asking discovery questions?" "Well, I just want to find out what's going on." I says, "Isn't that his job over there? That's what he's supposed to do. He's supposed to present his case as the prosecutor, trier of the case. You're the trier of fact, he's the trier of the case." I said, "If you're going to operate as the judge and the prosecutor, I'm going to object on the record as a mistrial. He said, okay, I'll let you enter that on the record. Go ahead. I said, okay, let it be entered on the record as an appealable issue. He said, okay. He said, now it's on the record. He said, let me ask you this. You get a ticket on September the 30th? I said, yes, sir. He said, well, let me ask you this. Do you have any plates on your car? I says, no, sir. And I don't intend to get any. And, of course, all the people in the court, oh, this guy's going to jail. Watch this. This is going to be good. He says to me, he says, I assume you have a very good reason for that. And I said, yes, sir, and I shut up. I waited. He said, can I hear it? I said, well, Your Honor, I said, I'm an unfranchised common law free man. I'm not a participant in any tontine schemes of limited liability on a joint venture for profit with an insurable interest requiring me to participate in these corporate Ponzi schemes. I'm just a little Joe from Kokomo. I live on the block. I travel at the common law. And I have a right to travel freely and unencumbered pursuant to Shapiro versus Thompson, and that right is so basic it doesn't even need to be mentioned. The state of Michigan arbitrarily and erroneously converted my right into a privilege and issued a license plate and a fee for it. Murdoch versus Pennsylvania says no state may convert a secured liberty into a privilege and issue a license and a fee for it. And if they do, Shuttlesworth versus Birmingham, Alabama says I can ignore the license and engage in the right with impunity. That means you can't punish me. Since I have relied on previous decisions of the U.S. Supreme Court and on constitutional defenses, I have a perfect defense for willfulness. I am immune to the prosecution. Therefore, prosecution counsel does not have a cause of action for which relief can be granted. I'd motion for dismissal with prejudice for failure to state a cause of action for which relief can be granted, and I'd kind of like to collect my costs and fees for having to defend this frivolous case. The judge starts reading the ticket. Told officer he'd just been waiting to get this ticket so he could fight it and beat it all the way to the Supreme Court. He laughed. He says, motion granted, and he ran off the bench before I could get my damages. So I went out in the hall. He went to the can. I waited for him. He came out of the can. I served him with my papers. He said, you didn't have to do that. I said, well, I didn't want you to be inconvenienced, Judge. He said, okay. He signed. I went back in the court as a casual thing just to see what kind of reaction would happen, and I sat down. About 2 cases later, this elderly gentleman gets up, and he stands up there, and he says, Your Honor, I'm not quite as knowledgeable as that young gentleman that was here just 2 cases ago, and I don't presume to understand all of the issues that he raised. But it really sounded good to me, and I'd kind of like to ditto everything he said on top of my case. Everybody broke out laughing. The judge says, all right, how many guys here didn't have no plates on their car? About 5 guys raised their hand. He says, okay, everybody dismissed. Get the hell out of here. And everybody broke out laughing. It was like, you know, at the carnival on Christmas or something, you know. It was the carnival atmosphere. So I'm telling you, you can affect change. And see, they had all figured. They said, watch this guy's going to jail. And then all of a sudden, boom, out jumped. And I mean, I'm telling you, it's this little book right here. This book. You know what's in this book, you have power. Knowledge is power. You know what's in this book, and you know how to exercise your rights in a timely fashion. You have constitutional right.
Welcome to the show.
Glad to be here.
Charlie, do you have a driver's license?
No, sir, I haven't. I don't drive commercially.
You don't drive commercially, I see. So you don't need a driver's license?
If you're not being paid, there's no need for a driver's license.
So if I was getting paid to haul goods and services, or I was a taxi driver...
You would have to have a driver's license. That's commerce.
That's commerce. But you don't drive in commerce, so you haven't had a driver's license for how many years, Charlie?
37 years.
What happens, Charlie, when the police pull you over and they think you're speeding or you didn't signal?
Well, now they just shake their finger at me or tell me to have a nice day.
Really?
Yes, sir.
Well, let's see. If I was a cop, I pull up, I say, may I see your driver's license, please?
I don't have one.
Why don't you have one? You're driving a car.
I don't want one. And I'm not driving. I'm traveling.
I see. Well, what if I just take you to jail?
Fine with me. But we'll be hooked to the hip. We'll be hooked at the hip for the next 5 years in federal court.
In federal court. So you're going to sue me, the police officer, if I take you to jail because you don't have a driver's license?
Yes, sir.
I think the judge will rule in my favor.
I don't think so.
Oh, so that's how it goes.
That's how it goes.
And you had one of those cases, Charlie, didn't you?
I filed suit in 1975 against 16 state officials, including Governor Reagan and all of their wives.
And all of their wives?
Yes, sir. When the officer pulls his red lights on you, he's declaring an emergency. That's a felony when there is no emergency. So he's already violated his job oath of office when he turns his red lights on to stop you. And then in my case, if he interferes with my right to travel, he's violating the Constitution of the United States.
Wow.
He becomes an imposter in the office of, he becomes a imposter in his office. And therefore he's taking his wages under false pretenses. And that's fraud.
And you've taken people to court?
Yes, sir.
Did Mrs. Reagan?
And we're back. I do hope you enjoyed those videos. One from the great Carl Miller. I feel like it's awesome. I mean, if you look on TikTok, you can find so many of these videos. I mean, if you want, you can follow me at Georgie350 on TikTok, and I repost nothing but gold. So you're welcome. Now, we're going to talk about the United States versus the United States of America. The Constitution was a commercial compact or a contract in the form of a trust between states, giving the federal government limited powers. The Bill of Rights was meant not as our source of rights, but as further limitations on the federal government. Our forefathers saw the potential for danger in the U.S. Constitution. To ensure the Constitution was not presumed to be our source of rights, the 10th Amendment was added. I will use a quote from Thomas Jefferson, February 15th, 1791, where he quotes the 10th Amendment. I consider the foundation of the Constitution as laid on this ground, that all powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states or to the people. To take a single step beyond the boundaries thus specially drawn around the powers of Congress is to take possession of a boundless field of power, no longer susceptible of any definition. That was from Thomas Jefferson. The created United States government cannot define the rights of their creator, the American people. 3 forms of law were granted to the Constitution: common law, equity or contract law, and admiralty law. Each had their own jurisdiction and purpose. Jurisdiction has many facets dealing with the various aspects as modalities of law and justice. Example is tort, that's T-O-R-T, or civil law. Admiralty law, or law merchant contract law, real property law, statute law, criminal law, and constitutional law, to name a few of the fields of jurisprudence. The court must be sitting in the proper jurisdiction to render justice. No court has the discretion to hear a case that falls outside of its subject matter jurisdiction. Most local courts today sit in the jurisdiction of admiralty law or merchant contract law, utilizing the Uniform Commercial Code, so anything you see that says UCC, as the authority for their moving. 1865 13th Amendment. People could volunteer into slavery by accepting federal benefits. If you didn't understand me, I said the 13th Amendment, people could volunteer into slavery by accepting federal benefits. In 1868, a privately owned foreign British corporation called United States was created and incorporated in Delaware. In 1868, the 14th Amendment defined as 2 new legal entities: a citizen of the United States and a person, both subject to the federal government jurisdiction as agents/officers and or employees of government. It then stated that no state could infringe or deprive any U.S. citizen or person of their privileges and immunities as U.S. citizens. Are you following along? Of great importance was the use of the terms privileges and immunities as opposed to rights. So anytime they say it's a privilege to shut up. As persons or citizens of the private foreign United States corporation, they had no rights within that corporation. They possessed only privileges granted to them by that private foreign corporation called the United States. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. It defined a new legal entity, a citizen of the United States, as 1. A person naturalized or born within the United States, and 2. Subject to the jurisdiction thereof, that is, subject to the jurisdiction of the United States. And then they said, note that both conditions must be fulfilled to be considered a U.S. citizen. Consequently, any man claiming the status of a U.S. citizen is affirming that he was born or naturalized in the United States and that he is subject to the jurisdiction of the property corporation called the United States and its statutes and courts, thereby exercising his unlimited right to contract and voluntarily waiving his rights under the common law and guaranteed by the Constitution. So in 1871, the District of Columbia Incorporation Act of 1871 was passed by Congress, creating a municipal government as a privately owned corporation that took control of D.C. In subsequent statutes in 1882 and later passed by Congress, the federal government became, in fact, the private foreign corporation called the United States, incorporated in 1868 and based in Washington, D.C. Boom. Further, in subsequent statutes, the term United States meant only the District of Columbia, not the various states of the Union under the Constitution. Do I need to repeat that? The term United States meant only the District of Columbia, not the various states of the Union under the Constitution. In 1913, the Federal Reserve central banks were created. 1933, President Roosevelt put into effect the Trading with the Enemies Act. This applied only to the federal citizens, aka U.S. citizens, as defined in the 14th Amendment. In 1933, President Roosevelt took the gold away from the people who were not lawfully required to relinquish it, and who then had no money with which to pay their debts. Since 1933, debts are never paid. They are simply, quote, discharged. March 9th, 1933, ownership, or the legal title of all property, is in the state. Individual ownership is only equitable. That's a user title. Use must be in accordance with law and subordinate to the necessities of the state. President Roosevelt, this is in 1933, he signed H.J.R. 192, June 5th of 1933. Passed by Congress. Since the government had taken the gold and the people had no money, the government would pay the debts for the people, thereby giving them unlimited credit. Whoever has the gold pays the bills. This legislation states that one cannot demand from you a certain form of currency, since any form and all forms of currency are your credit. If they do, they are in legal breach of public policy. PL 73-10. Not only does this insurance policy protect the legislators from conviction for fraud and treason, but it also protects the people from damages caused by the feds. 1938. The U.S. Supreme Court's Erie Railroad Company v. Tompkins, 304 U.S. .64, 1938, decision made contracts the rule in court. This ruling voided the long-standing Swift v. Tyson, 16 PET.141 U.S.18. No other law or court decisions prior to 1938 could be cited in future court cases. In effect, Erie Railroad Company v. Tompkins made contracts or contract law or UCC admiralty law, not the common law and the Constitution, the rule in the courts under the Commercial Act. The Supreme Court ruled that all federal cases will be judged under the Negotiable Instruments Law. There would be no more decisions based on the common law at the federal level. Prior to 1938, the U.S. Supreme Court was dealing with public law, that is, the common law codified as statutes. Since 1938, the Supreme Court has dealt with public policy, that is, private commercial law created through contracts. 1946, the government and court system was lost through the Administrative Procedures Act. 1965, silver was removed as a means for paying debt. The Uniform Commercial Code became the supreme law of the land concerning the banking system. The courts were pulled together in admiralty/administrative and civil law, thereby removing the innocent plea under the common law, thereby reversing innocent until proven guilty to guilty until proven innocent. Securities replaced substance as collateral for debts. Debt instruments with collateral and accommodation parties could be used instead of money. The courts could uphold the security instruments which depended upon commercial fictions as a bias for compelling payment or performance. In 1966, the Federal Tax Lien Act, the entire taxing and the monetary systems are hereby placed under the UCC, the fucking Uniform Commercial Code. The word person in legal terminology is perceived as a general word which normally includes in its scope a variety of entities other than human beings. You can see example 1, U.S.C, section 1, Church of Scientology v. U.S. Department of Justice, 612 F.2D 417, 425. One of the very first sections of the state statutes will have a section listed entitled Definitions. Carefully study this section of the statutes and you will find a portion that reads similar to this. You will hear the singular includes the plural and vice versa. Gender-specific language includes the other gender and neuter. The word person includes individuals, children, firms, associations, joint adventures, partnerships, estates, trusts, business trusts, syndicates, fiduciaries, corporations, and all other groups or combinations. The word person is a fictional legal entity. A fictional legal entity is a person. A man or woman is real and not legal fiction, and therefore, by definition, is not a person. So you can be a person or you can be a real man or woman. They say, note, however, the definitions in the statutes do not list man or woman. Therefore, they are excluded from all the statutes or the legislative acts. Under the rule of construction, expressio unis est exclusio alturis, I'm pretty sure that's Latin, where a statute or constitution enumerates things on which it is to operate or forbids certain things. It is ordinarily to be construed as excluding from its operation all those not expressly mentioned. Generally, words in a statute should be given their plain and ordinary meaning. When a statute does not specifically define words, such words should be construed in their common or ordinary sense to the effect that the rules used in construing statutes are also applicable in the construction of the Constitution. It is a fundamental rule of statutory construction that words of common usage when used in a statute should be construed in their plain and ordinary sense. If you carefully read statute laws enacted by your state legislator, you will also notice that they are all written with phrases similar to these 5 examples. A person commits the offense of failure to carry a license if the person, blah, blah, blah. A person commits the offense of failure to register a vehicle if the person, blah, blah, blah. You get the point. They all say a person. Notice that only persons can commit these state legislator created crimes called acts or statutes. A crime, by definition, is an offense committed against the state. If you commit an offense against a human, it is called a tort. You remember? I said that's that T-O-R-T, tort. Examples of torts would be any personal injury, slander, or defamation of character. So how does someone become a person and subject to regulation by the state and statutes and laws? There is only one way: contract. You must ask the state for permission to volunteer to become a state person. You must volunteer because the U.S. Constitution forbids the state from compelling you into slavery or involuntary servitude. This is found in the 13th and 14th Amendments. Okay, the 13th Amendment, if you don't know, Section 1, neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States, or any place subject to their jurisdiction. 14th Amendment, which defined the term citizen of the United States. Section 1, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. It's of great importance that both conditions must be met in order for a man to be a citizen of the United States. All persons born or naturalized in the United States and subject to the jurisdiction thereof, the United States. If you were born in Vermont but never agreed by contract to be subject to the jurisdiction of the United States, then you can assert you are a citizen of Vermont but not a citizen of the United States. By doing so, you are not subject to any statutes passed by Congress or any federal regulations. The catch is that when you walk into any court, that court makes the presumption that you are a citizen of the United States and therefore subject to that court's jurisdiction. And under the common law, a presumption not rebuted becomes a fact in law, meaning that you must object in writing and verbally, a lot of times, to their presumption and make them prove it, since any presumption challenged by man in a court must be proven by that court, as the burden of proof always falls upon the one making the claim. Further, you could assert that you are neither a citizen of any state nor a citizen of the United States, and both that state and the United States would have to prove otherwise. You become a state-created statutory by taking up residency with the state and stepping into the office of person. You must hold an office within the state government in order for that state government to regulate and control you. And before we get into the legislative office and all that stuff, I just want to take a quick break, and I'm going to see if we have video to watch, and if not, we'll be right back. Thank you.
The straw man is your name written in block letters. Very simple. It was done at birth. What the government did, or the corporations now, not government, what they did is they took your birth certificate and made a second birth certificate with a trust, a Sisti QV trust. They made it in all block letters. And for them to interact with you, they have to interact with you as a fiction, because they're all corporations. Corporation cannot interact with real people. So they made a straw man. They call it a straw man because it has no soul and is spiritually dead. This is happening since the early 1900s. What they've done is really fraud, because they're fraudulently taking your child's birth certificate and make it into a dead entity. The dead entity birth certificate is making billions. So your straw man is considered a dead entity and the corporation can interact with it. If you have to go to court, it's not going to be in your real name because they don't have it. All they have is the dead entity. A signature is under the UCC, which is the fiction, the straw man. Your autograph is the real person. So if you go up to a movie star and says, "Can I have your autograph?" You never say, "Can I have your signature?" It's always autograph because you have flesh and blood. Signature is what you're signing every time they can go into your account and take money.
And every time you do sign a piece of paper, you can bet that that signature of yours is being monetized, securitized.
It is. By the banks, by everybody that you, wherever you sign, credit cards, everything.
And we're back. We did have a video. Kind of try to help explain, with the whole straw man concept about how we're dead, technically. But now we're going to move on to, this is the last little bit that, I guess it's not even a little, this is the last bit I'm going to talk about before we end, definitely part one. So, the legislator cannot lawfully control you because you are a flesh and blood human being. God alone created you, and by right of creation, He alone can control you. It is the nature of law that what one creates, one controls. This is natural law. This natural law is the force that binds a creature to its creator. God created us, and we are, therefore, subject to His laws, whether or not we acknowledge Him as our creator. The way the state gets around God's law and thereby controls the people is by creating only an office and not a real human. This office is titled a person, and then the legislator claims that you are filling that office. Legislators erroneously now think that they can make laws that also control men. They create entire bodies of laws, motor vehicle code, building code, compulsory education laws, and so on, ad nuancem. They still cannot control men or women, but they can now control the office they created. And look who is sitting in that office of a person. You. Then they create government departments to administer regulations to these offices. Within these administrative departments of state government are hundreds of other state-created offices. There is everything from the office of janitor to the office of governor. But these administrative departments cannot function properly unless they have subjects to regulate. The legislator obtains these subjects by creating an office that nobody even realizes to be an official state of office. They have created the office of person. The state creates many other offices such as police officer, prosecutor, judge, etc., and everyone understands this concept. However, what most people fail to recognize and understand is that most common state official of all the office of person, anyone filling one of these state offices is subject to regulation by their creator, the state legislator. Through the state-created office of person, the state gains its authority to regulate, control, and judge you, the real human. What they have done is apply the natural law principle, what one creates, one controls. A look in Webster's dictionary reveals the origin of the word person. It literally means the mask an actor wears. The person, or persona, is not the real man or woman, rather it is an artificial representation. The legislator creates office of person, which is a mask. They cannot create real people. Only God can do that. But they can create the office of person, which is merely a mask. And then they persuade a flesh and blood human being to put on that mask by offering a fictitious privilege such as a driver's license. Now, the legislator has gained complete control over both the mask and the actor behind the mask. Now, common law. Distinctions between areas of jurisdiction are typically codified in a national constitution. In most common law systems, jurisdiction is conceptually divided between jurisdiction over the subject matter of a case and jurisdiction over the persona of the litigants. Sometimes a court may exercise a jurisdiction over property located within the perimeter of its power without regard to personal jurisdiction over the litigants. This is called jurisdiction in rem. A court whose subject matter jurisdiction is limited to certain types of controversies, for example, suites in admiralty or suites where the monetary amount sought is less than a specified sum, is sometimes referred to as a court of special jurisdiction or court of limited jurisdiction. A court whose subject matter is not limited to certain types of controversy is referred to as a court of general jurisdiction. In the United States, each state has courts of general jurisdiction. Most states also have some courts of limited jurisdiction. Federal courts, those operated by the federal government, are courts of limited jurisdiction. Federal jurisdiction is divided into federal question jurisdiction and diversity jurisdiction. The United States District Courts may hear only cases arising under federal law and treaties, cases involving ambassadors, admiralty cases, controversies between states or between a state and citizen of another state, lawsuits involving citizens of different states, and against foreign states and citizens. Certain courts, particularly the United States Supreme Court and most state Supreme Courts, have discretionary jurisdiction, meaning that they can choose which cases to hear from among all of the cases presented on appeal. Such courts generally only choose to hear cases that would settle important and controversial points of law. Through these courts have discretion to deny cases they otherwise could adjudicate. No court has the discretion to hear a case that falls outside of its subject matter jurisdiction. Executive jurisdiction. Jurisdiction also denotes the area over which the executive or legislative powers of law of a government extend. Similarly, the term also denotes the territory over which a state exerts or claims sovereignty or power, sometimes known as territorial jurisdiction. In private international law, a supranational organization, an example would be the European Union, a nation-state or province, another example would be a subnational state, and a federation, as can be found in Australia, Brazil, India, Mexico, and the United States. They all exercise jurisdiction, although the problem of forum shopping is growing. The most sacred of liberties, of which Justice Tolman spoke, was personal liberty. The definition of personal liberty is personal liberty, or the right to enjoyment of life, liberty, and one of the fundamental or natural rights which has been protected by its inclusion as a guaranteed in the various constitutions, which is not derived from or dependent on the U.S. Constitution, which may not be submitted to a vote and may not depend on the outcome of an election. It is one of the most sacred and valuable rights, as sacred as the rights to private property, and is regarded as inalienable. And that's from 16 CJS Constitutional Law, Section 202, page 987. And here's another, this is from Miranda versus Arizona, 384 U.S. 43, 491. Where rights secured by the Constitution are involved, there can be no rule-making or legislation which would abrogate them. Here's another one from Hoke versus Henderson, 15 NC 15. To be that statute which would deprive a citizen of the rights of person or property without a regular trial according to the course and usage of the common law would not be the law of the land. Law of the land. There's the law of the land and the law of water. This one's Simons versus United States, 390 U.S. 389. We find it intolerable that one constitutional right should have to be surrendered in order to assert another. Okay. Constitutional rights cannot be denied simply because of hostility to their assertions and exercise. Vindication of conceded constitutional rights cannot be made dependent upon any theory that is less expensive to deny them than to afford them. That's Watson versus Memphis, 375 U.S. 526. When the state allows the formation of a corporation, it may control its creation by establishing guidelines, statutes, for its operation, or characters. Corporations who use the roads in the course of business do not use the roads in the ordinary course of life. There is a difference between a corporation and an individual. The United States Supreme Court has stated, "We are of the opinion that there is a clear distinction in this particular between an individual and a corporation, and that the latter has no right to refuse to submit its books and papers for examination on the suite of the state. The individual may stand upon his constitutional rights as a citizen. He is entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no duty to the state or to his neighbors to divulge his business or to open his doors to investigation so far as it may tend to incriminate him. He owes no such duty to the state since he receives nothing therefrom, beyond the protection of his life, liberty, and property. His rights are such as the law of the land, the common law, long antecedent to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are the refusal to incriminate himself, and immunity of himself and his property from arrest or seizure except under warrant of law. He owes nothing to the public so long as he does not trespass upon their rights. Upon the other hand, a corporation is a creature of the state. It is presumed to be incorporated for the benefit of the public. It receives certain special privileges and franchises and holds them subject to the laws of the state and the limitations of character. Its rights to act as a corporation are only preserved to it so long as it obeys the laws of creation. There is a reserved right in the legislature to investigate its contracts and find out whether it has exceeded its powers. It would be a strange anomaly to hold that the state, having charactered a corporation to make use of certain franchises, could not, in exercise of its sovereignty, inquire how those franchises had been employed and whether they had been abused, and demand the production of corporate books and papers for that purpose." That's Hale v. Hinckley, 201 U.S. 43, 75 through 74 in 1905. He says, "We know that Hale v. Hinckley was decided in 1905 in the U.S. Supreme Court. Since it was the U.S. Supreme Court, the case is binding on all courts of the land until another U.S. Supreme Court case says it isn't. Has another Supreme Court case overturned Hale v. Hinckley? The answer is no. And this was revised in 2014, and I'm not going to lie, I do not know if it has been overturned. I will check on that and let you know in part 2. They say, as a matter of fact, since 1905, the Supreme Court has cited Hale v. Hinckley a total of 144 times. A fact more astounding is that since 1905, Hale v. Hinckley has been cited by all the federal and state appellate court systems a total of over 1,600 times. None of the various issues of this case has ever been overruled. Corporations engage in mercantile equity fall under purview of the state's admiralty jurisdiction, and the public at large must be protected from their activities as they are engaged in business for profit. Based upon the fundamental ground that the sovereign state has the plenary control of the streets and highways and the exercise of its police power, may absolutely prohibit the use of the streets as a place for the prosecution of a private business for gain. They all recognize the fundamental distinction between the ordinary right of the citizen to use the streets in the usual way and the use of the streets as a place of business or a main instrumentally of business for private gain. The former is a common right. The latter is an extraordinary use. As to the former, the legislative power is confined to regulation. As to the latter, it is plenary and extends even to absolute prohibition. Prohibition, Jesus. Extends to absolute prohibition. Since the use of the streets by a common carrier in the prosecution of its business as such is not a right but a mere license of privilege. That's Hadfield versus London, 98 Wash, 6571, 168, page 516. They say it'll be necessary to review early cases and legal authority in order to reach a lawful, correct theory dealing with this right or privilege. We will attempt to reach a sound conclusion as to what is a right to use the road and what is a privilege to use the road. Once reaching this determination, we shall then apply those positions to modern case decisions. Where rights secured by the Constitution are involved, there can be no rule making or legislation which would abrogate them. And that's Miranda versus Arizona, 384 U.S. 436, 491. And the claim and exercise of a constitutional right cannot be converted into a crime. And that's Miller versus U.S. 230 F. 486, 489. Streets and highways are established and maintained for the purpose of, I don't know what that, Alright, one moment. I don't know what happened there. We're going to go ahead and I got one last video, so I'll play this video and then we'll finish it up and we'll be right back. Enjoy this video from Jordan Maxwell.
Let me give you a quick example about the maritime law, the law of water, the law of the sea. Money is water by law. This is why all ships are female by law. All ships, rocket ship, sailing ship, it doesn't matter. If it's a ship, it's female because the captain always refers to his ship as she. Right. She's a good ship or she's done this. Why she? Because she delivers the product. Without she, there is no product.
It's a vessel. It's a
Of course it is a vessel. So is your body. It's a vessel that produces a product.
Right.
When it's into harbor, it stops, and where it parks is called its berth. It's berthing a ship, or she sits in her berth. And every item on that ship, coming out that ship, is of money. It's money changing hands.
Right.
It came in on water. So every piece has to have what is called a certificate of manifest, because she is sitting in her berth. That's why when you were born, your mother's water broke. You were inside a container of water. Her water broke, and you came out, and therefore you have to have a birth certificate. And it's got to be signed by the dock, because that's where the ship is sitting. At the dock is where the ship sits. So once you begin to see how the words and terms are all based on maritime admiralty, the law of water, the cash flow, the liquid asset, it goes all the way back to the English or British domination of the seas.
The truth.
All right. I don't know what happened, but my computer was glitching out. But that was Jordan Maxwell. He's not with us anymore, but if you type his name in anywhere, I would suggest just watching everything he's ever did. But let's go ahead and wrap this up. In 1938, Erie Railroad versus Tompkins made contracts the rule in the courts. Commercial law. The Supreme Court ruled that all federal cases will be judged under negotiable instruments law, or commercial law. There would be no more decisions based on the common law at the federal level. Prior to 1938, the Supreme Court was dealing with public law. Since 1938, the Supreme Court has dealt with public policy. The charge that Mr. This overturned a standing I did it again. The charge that overturned a standing decision of over 100 years, Swift v. Tyson, which was a very similar case, and the decision of the Supreme Court in Swift v. Tyson was that in any case of this type, the court would judge the case on common law of the state where the incident occurred, in this case, Pennsylvania. Further, since the Erie Railroad v. Tompkins 1938 ruling, no other law or Supreme Court ruling prior to 1938 can be cited in cases in court. You must realize that the court you are standing in is an Admiralty Law Merchant Court under the Uniform Commercial Code, which recognizes only two classes of entities, creditors and debitors, dealing only in terms and conditions of contractual obligations. It is not a constitutional court of proper jurisdiction to secure the rights of sovereign citizens. And that is the end of part 1. Like I said, there's so much more to go through. I mean, from the flag, it's insane. It truly is. I mean, I still have a driver's license and all that. This is something that I would like to look into, because I mean, I currently am, but I mean, it's just wild to think about, and it kind of sucks to think about how we just get fucked by the government Monday through Friday, Saturday, and Sunday. It's dumb. But with that, that is going to be the end of today's episode. I do hope you enjoyed it. And again, if you did, go ahead. You can leave me a 5-star review or rating. It helps out a lot. But just know you don't have to do either of those things. All I want is for you to enjoy the show. And check out our affiliates and use promo code Georgie350 for some dope-ass clothes. Don't forget, you can download the Flat Earth Sun and Moon Zodiac Clock app and use the referral code, or use the code Georgie, so they know where you came from. For $5 a month, you can watch the video version before anyone else at patreon.com/onceupon785. My email, again, is onceupon785@proton.me. As always, I'm your host, Georgie350. Let's hit him with the outro. Bitch. Have a good night.
Yeah. Middle of the map, can't swear I'm at. You can say I'm whack, it's just not a fact. Can't tell if I'm awake or I'm in a dream. I just know I'm geeked on amphetamines. Never was a habit, now I gotta have it. Never was a fiend, now I am an addict. Never was a habit, now I gotta have it. Never was a fiend.